Good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 43, which involves the corporate business entity form. So we're going to be looking at its general characteristics as well as formation issues that can arise. The overall learning objectives, I want us to be able to understand a basic historical background of the corporate entity form. We'll talk about how partnerships compare with corporations, and then we'll look at what the corporation is as a legal entity and how corporate owners can lose their limited liability by certain actions. So that's the overall kind of like big picture or takeaway for this chapter. In terms of just a brief history, the corporate form dates back nearly 1800 years BC, so it's been around for millennia. This idea of this business entity form, and it's been a modern fixture in contemporary society and almost every society around the globe in recent history. The original purposes for a corporation centered around religious and governmental purposes, as you can imagine, from centuries or millennia ago. Eventually, what was added in was the idea of corporations becoming part of like commercial or commerce activities. Some of the earliest, kind of like commercial uses of corporations were as like a joint stock company. So under this model, investors contributed capital and only risked their investments, not their overall personal fortune. So that has been a lure of corporations, is that normally you're only going to be liable to the extent of your investment. Once we gained our independence as a nation, so here in the United States, the late 1700s, most states have granted charters for corporations and corporate forms. And so this is what allows these entity forms to transact business either intrastate or interstate. Delaware seems to be the one that has the most favorable, environment for corporations. So a lot of corporations are headquartered in Delaware because of favorable tax and other regulatory benefits that flow from being located in that particular state. This is a good kind of just a quick, visual summary. And again, I won't read all this, but just, to understand, partnerships versus corporations. And so I've kind of categorized them based on ease of formation, ownership control, transferability of interest, financing, and taxation. So it's a good thing to always, reference when you're looking at questions involving corporations versus partnerships. Technically, a corporation is considered an artificial person under U.S. law. And so it exists as a separate and distinct entity possessing, certain powers and rights. Normally, shareholders are not going to be personally liable for corporate obligations, only the extent of what their investment is. So if I'm worth $10 million and I have $1 million of stock in this company, the normal rule is that if the company, exposes itself to some sort of liability event, my $1 million might be on the stake, but the rest of my fortune is insulated or protected. The concept that a corporation is this like legal person means that the corporation's property is technically not owned by persons who own shares, but by the corporation itself. So whether we're talking about debts, if we're talking about free speech rights, whatever it is, we're pretending that the corporation is this living, breathing thing that does have rights just as humans does. Common forms of corporations, and I think I talked a little bit about this in the last chapter. If it's a private business corporation, that's stock that's sold on any public or publicly held, exchange, like the New York Stock Exchange. And, that's what I think most people probably envision or think of when they think of a corporation. So its value per share fluctuates daily on these open public markets. It can value, minute to minute, second to second sometimes, depending on what the particular issue is. Closed corporations are not traded publicly, and they're limited or in terms of who is allowed to own them to a small number of people. So it's usually these closely held corporations are popular for more family-run businesses. And then the sub-chapter S corporations, excuse me, This allows shareholders to be treated as partners for tax purposes, but retain the benefit of limited liability. Again, if you want to have that S Corp, you have to have less than 100 shareholders. Corporations can be formed for purposes other than conducting business. While most do enjoy being profitable, there are some that, I think it's eleemosynary, which are like nonprofit corporations, and then there are public corporations, which are like municipal corporations, and they exist to provide government services. Obviously, they do not have at their purpose that being profit. So, when you're trying to pierce the corporate veil, this is where you're trying to get through that limited liability shield. Normally that has broad appeal to investors. It's like, I want to be able to know that my investment is only going to be restricted to, that whatever that level of investment is. I'm not going to be pulling in all of my assets that I have personally or maybe in other business enterprises. Unlimited personal liability can be pierced if any of the following things are proven. So maybe failure to maintain adequate corporate records, commingling of assets, grossly inadequate capitalization, maybe just an overall determination that injustice would result if the corporate entity were recognized. So, those are some things that judges will look at, because it has to be a judicial determination to make that call. Classifications, so we have nonprofit corporations, we have public corporations, we have professional corporations. So these are usually business associations, and it could be attorneys, physicians, accountants, CPAs. Those are examples of professional corporations. And then you have your traditional business corporations that are publicly held for profit. About 90% of all U.S. corporations are closely held, so that idea of having shareholders that are like 30 or less in number, that's most corporations in the U.S. Even though, the big corporations seem to get all the attention, the Amazon, the Apple, the Microsoft, and so on, that have literally tens of thousands of shareholders, most corporations are going to be fairly small in nature. In terms of the corporate organization, charter function, once it's issued by the state, the corporate charter, then that gives the corporation legal effect as an entity. Again, state selection, trying to decide where you want to incorporate, it does require some important things to consider. So, Delaware, I mentioned before, is a popular state because they have low incorporation fees, no minimal capital requirement, no sales tax, no taxation of non-resident shareholders, no income tax for doing business outside Delaware. So those are usually some big draws for corporations to say, look, we are going to be transacting business in all these other states, but Delaware has the most favorable environment in which to conduct business. When we talk about corporate organization, usually pre-corporate status, you have an individual or individuals that are referred to as promoters. And this person, he or she is a fiduciary, and they bring together persons that are interested in the enterprise and sets everything in motion in order for a business corporation to form. So a promoter is going to be personally liable for contracts that they have made for the corporation before its existence. Promoters are also going to be responsible for any torts that are committed in connection with their activities as a promoter for this potential corporation. Pre-incorporation stock subscriptions, so promoters sometimes seek to obtain offers by potential investors for the purchase of stock. And so normally these offers are going to be treated as irrevocable for 6 months. If we're looking at the issue of actual execution and the filing of articles of incorporation, that includes corporate name, purpose, the total number of shares, the share classes if you have different classes, par value, limits on shareholder rights, restrictions, and so on. If we're dealing with, let's say, an organizational meeting of the directors, so once that certificate of incorporation has been issued, then normally a board of directors is impaneled And what they do in part is to adopt bylaws, they elect officers, they accept promoter contracts, and they give authority to various officers of the corporation. So that's, once you have this promoter, and once they are trying to advance this idea of, creating this corporation, they get through all the hurdles, and it actually is filed and executed. Then you gather together directors, and they're the ones that will actually, they do the nuts and bolts to create the business as a whole. This is a good summary of the liability during formation. So whether you're talking about from the promoter side or from the corporation side, and so again, I won't read all this to you, but it is a good summary or overview for things to consider. Promoters usually have some unique abilities and opportunities, to really have success. But again, you've got to be very careful if you're entering into these contracts. You don't want to be left being the responsible party. You want to make sure that whoever you're representing, these individuals that want to kind of start the corporation, that they will have the follow through necessary, so that they will adopt all the contracts that you have entered into, so you're not held kind of like holding the bag, so to speak. When we talk about de jure versus de facto corporations, de jure corporations, this is when promoters meet the requirements of a corporation in terms of its formation elements. At that point, then we can say a valid legal entity, like by law or de jure, has been formed. De facto is where you have compliance with maybe some, but not all of the hoops you have to jump through for a corporation. And so the corporation maybe is functioning, but technically, it hasn't really arrived yet as like a de jure corporation would have been. Compliance, even for like a de facto corporation, does not exist, if there is no corporation. So that's critical to understand. You've got to have compliance in order for that corporate entity form to kind of spring into being. If there's no corporation, then the law is going to treat the business simply as a partnership, with the ability to go after partners personally if there is an event that gives rise to liability. So, always remember that. That is the fear that if you don't successfully make that leap and have that status as a corporation, we'll just by default say it's corporate, or treat it, as a partnership. And with that, as a general partner, you're going to be exposed personally to all this liability. The corporation by estoppel is the idea that officers or directors can be estopped or prevented from denying the legal existence of a corporation if they did business in the name of the corporation. So this is really trying to address the problem of, whether it's a promoter or some corporate officer that they know that the corporation is not fully formed yet, but they do business pretending it is. And then when you later find out that it isn't, and you go after them personally, because that's that standard, and they try and say, well, I want to try and not have this apply to me, that would be corporation by estoppel. So anyway, brief, I know, overview of corporations. We'll kind of look more into it as we go through the rest of this course, but as you have questions, please feel free to message me. You can email, call, or text me anytime. But have a good, safe, productive week, and I'll be chatting with you all online. Thank you so much.